Matter to come before the court this morning is Melissa Schmitt versus Shaine Ward. Both sides will have 15 minutes to present oral argument this morning. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve any time, you let me know. I'm keeping track of the clock and I will keep you apprised of the passage of time. We have read the briefs and we're ready to see when you are.
Please, this court, counsel. My name is Frank Cimino. I am here on behalf of the appellant, Mr. Ward. I filed this brief based upon the fact that I was very concerned about how the entry of July the 8th dealing with funds being placed into my account was placed on the record. I have no motion that was informed me in the notice date of that hearing. There was no notice provided to me in any fashion, whether from the court or from the clerk's office, from the clerk's office. I believe I've attached my efforts at trying to go through Jody Burka, who was a court reporter, trying to find any kind of a record of a hearing that occurred on that day, July the 8th, regarding that motion to put me in a situation where I would be pretty much of a receiver operating the business through my IOLTA account. The preliminaries for this basically are that on July the 7th, unfortunately, Ms. Schmidt's grandmother passed away, and as a result of that, she reached out to Shaine Ward, my client, and asked that she be able to pick the child up at 10 o'clock on Sunday. That was on July the 7th. I believe that was around 5 o'clock on that day. I believe the records reflect that our family wizard showed that around 10:56, Mr. Ward responded, said the boy had tried to contact his mom a couple of times, couldn't get through, that he would be available that Sunday for his mother to pick him up. The next, our family wizard is probably July the 8th at about 8:16, and the mother indicating that I'm not going to play games with you, I can't meet, well, as I understand it, and I don't know the geography, but apparently she wanted to go to Mingo Junction. He was camping, was relatively close to Mingo Junction, said he would meet her there. Apparently she responded at 8:16 in the morning on the 8th, indicating, I'm not going to play games with trying to meet up with you, I'm going to court to get a court order. So the next thing that happens apparently is he responds to her and indicates that, and that's at 8:17, the family wizard's in there, if you want him earlier than 7 o'clock, let me know. So the next thing we know is Ms. Gradsky is in court around 2:30 on the 8th and gets an ex parte order. And I did copies of that morning, maybe 10 o'clock. I got copies of the motion for the ex parte hearing, the affidavit regarding the ex parte motion. But that was all that I received on that date. And I had no idea that anything else was going to move forward. I did not appear at that. I certainly don't object. Mr. Ward didn't object to her, Ms. Schmitt taking the child to her mother's funeral and the next day her mass. That was not an issue. What is an issue, though, is that at that time, another order was prepared, the second order, apparently by Ms. Gradsky. It doesn't even reflect me as an attorney of record. The only signature line is Ms. Gradsky's on that order. And the order then apparently went on, indicating that they granted a motion that I had pending to continue because of a conflict in my schedule. And the wording that, and again, this is Ms. Gradsky preparing the entry, that indicates that, well, based upon the fact that you got a continuance, we're going to go ahead and make you the receiver through your IOLTA account of the Ranch Road properties. So that to me was challenging. We were here a couple of weeks ago regarding another entry where I feel as though wording was entered, put into an entry after a telephone conversation that was not part of our conversation. That entry I did not see, although it says approved by email. That entry I did not see for 2 days subsequently, wherein I got a call from my client on April the 1st for that March 30th entry, saying that an entry went on, and I said, I have no idea. I called their office, and I get an entry copy sent over to me at that day, 2 days after the entry had gone on. And that's strange, because that entry was dated, or time stamped 5:01 p.m. But anyway, the bottom line, my concern is, in this matter, is I had not received any notice about the hearing going forward on July the 8th regarding her request to have the IOLTA account become a part of the operation of Ranch Road property and my being the one to receive these monies from that property. And I did not receive notice, I was not served, and I appreciate the idea that, in my opinion, that's not appropriate.
Let me ask a question. Mr. Ward had filed a motion for continuance at some point prior to this.
We had done that, well, I had done it, I had a conflict in my schedule.
Okay, and there's no doubt that Attorney Grasky is the one who drafted the proposed order granting continuance.
If you look at the entries that we have, there's a series of entries in this case. There was one back in 2014, I believe, where the type was all the same. And that one, another attorney's name was written, I believe, by Ms. Gransky, indicating it's seen but not approved, or something like that, on that end. But all the typing is the same. I wasn't there, I certainly not asked her about it, but it sort of appears to me to be very, very identical.
Can you explain to me how this does qualify as a final appealable order?
Your Honor, I'm here because I'm offended by what happened and how it happened. To me,
We can't fix an offense, but we
Right.
can fix
I
a
appreciate-
final appealable order if it's possible. So I guess my question is, does it qualify as a final appealable order?
well, apparently the order was made to make me become the receiver of the income from this Ranch Road properties. And
But it hasn't been distributed anywhere yet, it's just sitting in your IELTS account. evidently.
I have no money in my Alta account, Your Honor. I have not taken any money in.
So there has been no proceeds from any rental from the Ranch Road property?
Delivered to my Alta account? No.
Trying to figure out where's the harm here.
Well, to me, Your Honor, I'm just offended by the way this proceeds. At one point, I mentioned to Ms. Gransky that orders are flying every which way, and I have no idea how or why. And that related both to the order that was on March the 30th, that's how that came about, and on this one. So that to me is
When you
big
prepared your
not
motion,
too.
when you first prepared your motion for continuance and you submitted it to the court, did you provide a proposed order granting the continuance?
I did not.
You did not, so to your knowledge, the court never granted or denied it.
Well, apparently this
Other than
order seems to
this.
say they granted it.
Okay, is that typical process in some kind of domestic relations court to provide a proposed order when you file a motion? The reason I'm
I'm just,
asking,
I'm sorry.
the court could have lined that out, had the court wanted to, they could have, because she's the one that prepared it, then the court could have just drawn a line through that sentence and it still could have been granted, correct?
The sentence dealing with me becoming their
Yeah, correct.
receiver? Yes. Yeah, I mean, I apologize. Thank you.
May it please the court, counsel. My name is Leslie Gransky, and I represent Mr. Schmitt in this matter. The record does not contain any indicia of an ex parte communication for the simple fact that none occurred. You're not hearing all of the facts in the oral argument, and frankly, the funeral issue is something of a red herring thrown in because of the accidental timing. There was a motion for receiver filed on June 24, 2015. It had been pending for almost a year when Mr. Ward filed a motion for stay, claiming that this court had said if the lower court had no jurisdiction, he had to respond to that, and that was copied to his counsel. He filed another motion to continue the initial hearing date, and that was granted. It was set for a date that was inconvenient to Mr. Ward, I understand that. All we were asking on June 30th is the date that the response was filed, and it said, if you're going to grant a continuance, please do something with the rent, which is not being applied to the mortgage on the case against Mr. Ward, but Ms. Schmitt in general division for $250,000. We asked just to hold the receiver, the rental property. I thought the best solution was to put it in the IOLTA account, because all attorneys must have IOLTA accounts of Mr. Ward. I didn't ask to put it in my IOLTA account. I thought Mr. Ward's counsel could have it. That was submitted with the response on June 30th. It's not only a tradition to submit a proposed entry with a motion for continuance, it is a local rule requirement. The person moving for a continuance here didn't submit an order, but there's no reason why the person opposing it or asking for conditions on it could not submit that order. I found the local rule provisions, they're in my brief. I don't remember the numbers off my head, but they are in there. So on June 30th, Mr. Ward was made aware that we wished to have July 1. We were aware that we wanted to have a condition, and it was a condition of holding some rent. It was not running a business, it was holding some rent, which could then have been released to Mr. Ward on further court order. But here we are a year later, and there's no funds available for anything. As I said, it was coincidental that the grandmother died between July 1st and July 8th, so that the second motion was filed. They were all served electronically, they're all on the docket. The proposed order submitted by Ms. Schmitt was rejected because it's a visiting judge, so you can't do the electronic Cougar filing, you have to have a paper copy to submit to the judge. And that notice is attached to our brief. I'm thinking I should file a formal motion to add these two documents from the Summit County Clerk of Courts into the record, because I noticed on the docket there's no docket reference to show those. But those are the actual Summit County documents you get when you submit an order. There's no skullduggery in this case. It was just an earnest attempt to move this case forward and to preserve some of the asset, the income being provided by this asset, which has been the source of so much strife, so many appeals, so much courtroom work. The order was served. It was approved by the judge, who could indeed have lined out the provision concerning the rental. The trial court took no erroneous action. I had no ex parte communication with the court. In fact, the appellant's brief shows that when I submitted the order, it was copied by email. This court should affirm the trial court. Thank you.
Counsel, real quick.
Sure.
What would be your response to Judge Schaefer's question regarding finality?
I didn't think it was a final order.
Thank you.
Thank you.
Counsel, you have 5 minutes for rebuttal if you.
Finality, Your Honor, I guess is an issue where this matter could be taken up to the court and presented to the court. My concern is how orders are being presented and executed and put on record or filed with the court. I believe that there are such rudimentary obligations that counsel have in relation to presenting a matter for the court to review that exist, and that if those are breached, I believe that the order is void. I believe that the order does not have the ability to move forward, and the only way of addressing that is to come to this court. There is no other way. I'm sorry.
No, I'm looking at, on July 1st, she filed a response to the motion for continuance. And I don't see on the document anywhere where you
Your Honor, in all honesty, maybe I was too naive, but I'm not aware of a matter being presented to the court that doesn't come on for a hearing, and people are notified, parties are notified of a hearing to address whatever has been presented to the court. I don't, and again, she calls it, it's not ex parte, but I don't know how else that entry, the second entry, got before the court. I appreciate the ex parte.
Your
Right.
response to the motion for continuance? Is that what you're talking about, her response to the motion for continuance?
And that's fine, and I have no problem with her doing that. But I still don't understand how that gets resolved as far as involving my IOTA account without it coming before the court on a hearing. Notice being provided. I'm also aware of the local rules. I apologize, I've practiced in 40 now. But whenever a matter gets set, it doesn't get set until the other party requests that it be set for a hearing. Now, apparently I've understood that or come to grips with that. But that is another local rule that apparently exists with the Domestic Relations Court. And I'm not aware of anybody requesting that that be set for a hearing. Anything be set for a hearing. She refers to things that were filed several years ago. I mean, when we've gone through this, there are any number of motions that are outstanding in this case that have not been set for a hearing. And they're pending, and apparently we're going to make some effort to try to address that issue as far as having a hearing set to address the outstanding motions. So that is something that is occurring. We have a hearing now set for June the 20th to begin to address the multitude of motions that are outstanding that have never been set for an actual hearing. So, you know, that's, I guess that's how I understand the matters should proceed. And to be honest with you, Your Honor, I don't know how someone just throws an entry and how the court becomes aware of this. Judge Giletto was a visiting judge. The motions that she's talking about being set for a, as far as getting a receiver set, that had to be 2 years ago or more. Well, how does Judge Giletto know about that? How does he even file when the case is on appeal and he doesn't have the file? That was what he told us when we began walked in the room. He doesn't have the file. He doesn't know what's in the file. So how does he know that there's a motion outstanding for a receiver to be appointed? That doesn't seem to fly, or that doesn't comprehend with me. That doesn't seem to make sense to me if something is not presented to him by somebody. I mean, that's been his position when this matter's been set for hearings in the past, that it's on appeal. I can't do anything with it. I don't have the file. I'm not to say that a few things have happened while I've been there. This one issue dealing with the school and the having her reiterate the idea that she is the one who makes the final school decisions on sports and things, which was a part of the entry of April the 17th, 2015. My concern about the 30th, whether that order went beyond when she prepared it, when the wording went beyond what was in the order that was on appeal. So all I can tell this court is that there are issues that, to me, there is no remedy available other than to try to address it with this court. Thank you.
Thank you both for your presentations this morning. Court will take the matter under advisement. We will issue a written decision within mailed to both sides as well as posted on the Hot Springs Court website. Thank you.